This is WPSL Port St. Lucie.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Hello, planet Earth. As I hear we are acquiring listeners in some far-reaching areas. So instead of the Treasure Coast, I'll say planet Earth. I am back this week. I was away last week, not for the reason that was intended.
That's okay.
I was supposed to be away because I was going to be a chaperone on my son's trip to Washington, D.C. with his high school band. And of all places, D.C. I wanted to go because I went to law school there. Haven't been back in over a quarter century.
Since law school?
No, I was back once since then.
Okay.
And I really wanted to go. Ended up not going. I'll tell you one time you don't want to call me. After I've had cough medicine.
Oh.
I ended up spending Saturday night in the hospital.
Oh, no.
Turns out, I had one of those rare adverse reactions to medicine. You know where they list all the possible reactions you can have?
And the really obscure one?
Right.
Okay.
At the very, very end, there are some very rare ones.
That's you.
Well, for the first time ever, I got hit with one of those. I took some cough medicine Saturday morning, and I went into the kitchen to make breakfast, and I cut 2 bagels, and I put them in the toaster, and I went away for a few minutes and came back to get them out of the toaster. There were no bagels in the toaster. And I looked at it and I said, how's that possible? Who took my bagels? Aaron was in D.C.
You were the only one there?
Well, okay.
Okay.
My girlfriend was arriving soon.
She came for bagels.
Yes. And so I actually looked in the garbage for the bagels, realized that something was wrong. I wasn't quite making the logical connections in my brain.
Ooh.
I couldn't get from point A to point B. So I sat down on the couch, and I started trying to figure things out. And every time I came up with an idea, I couldn't get to the end of the idea. So she arrives, and I tell her the bagel story, that the magical bagels that I had sliced and put into the toaster had disappeared. And that I was very confused and disoriented. Well, apparently I also had a very blank stare on my face.
Okay, so she was the actual voice of reason there who connected the dots.
Isn't the girlfriend always the voice of
Would
reason?
you just been sitting on the couch trying to figure it out all day until something more happened?
I probably would have been locked in a circle.
Wow.
So she says, I think we need to go to the hospital.
Yeah, let's take a little ride.
So we take a little ride to Tradition. And luckily, first thing in the morning, they're not that busy. They got busy later. And they take me in, and they send me to all the standard X-ray, CT scan, Doctor finally comes in, and I tell him what happened. And he says, well, that sounds like an adverse reaction to the medicine.
I mean, it almost sounds like a mini stroke in a way.
Well, you see, that's why I got kept overnight.
Yeah.
He says, I am certain from all the other test results, your blood work, everything else, I am certain that it was just a bad reaction.
Yeah, because they can tell that from a blood test.
But the doctor always says but. Why does the doctor say but? Because of lawyers.
Well, that and you never can always be completely sure. Every person's different.
Well, lawyers made him keep me overnight. The threat of malpractice suits.
And you're a lawyer, so.
Well, he didn't know that at the time. So he says, but I'd like to keep you overnight, have an MRI, make sure you didn't suffer, a stroke or a TIA. So I hear that, and I was ready to leave until I hear stroke and TIA.
Right, and then you're like, oh
then
my God.
I said, okay. Oh, I hate hospital beds. They're so uncomfortable.
Well, it beats the alternative, Stuart.
It does. So that's why I was gone Friday, folks. You can maybe still hear it in my voice. under the weather, and later hospitalized.
Wow.
But hey.
Well, glad you're
So
feeling a little better.
Don't call me after I've had cough syrup.
Did they tell you what was in the cough syrup that you should never, ever,
No, I
ever
just
have
will
again?
never have that brand again.
Okay.
I won't mention it. It's a common brand.
Yeah,
but,
well.
I'm sure it's fine for everybody else.
Oh.
I don't think, unless the Russians targeted me.
Here's the thing though, and I'm not saying as we age, things change. Years ago, I could be bit by a bee, no problem, no big deal. The last time I reacted tremendously, and now I'm like terrified of bees.
Are you trying to tell me I'm old?
Well, I think we're kind of the same age, so no.
Okay. Fair enough.
Yeah.
All right. So we are live now, and that means you can call us. It is 772-340-1590. And if you folks don't call, I'm going to have to sing. So I'm going to give you a little sample. Call me on the line. Call me between 10 and 11 on Fridays. Call me. You can call me on Fridays between 10 and 11. Look, if you don't want me to sing the whole song or go into Mana La Mancha or something like that, give us a call on 340-1590. That's what I'm here for. My sister is listening and she says, don't sing. Okay, well, when I go on my cruise, I definitely will be singing. All right, so we're going to move into a preliminary subject area that deals with nasty attorneys. The kind that give attorneys bad names. And it's interesting because it may not quite pass the borderline of violating the rules of professional conduct, but we do have a call, I think. Somebody likes my singing, or called me because they didn't like my singing. We got Bob?
Don first.
We got Don on line one. Hey, Don, how are you?
Good morning, Stuart. How are you today?
I'm doing great. How can I help you?
I have a question for you. Me and my wife, my sister-in-law died a couple of years ago,
Sorry to hear that.
and she was left as trustee of the estate.
Your wife
and
was?
My wife was, yes. Sorry.
Okay, so your wife is trustee
And
of the estate.
her nephew was the only survivor of the family, which was a minor at the time.
Okay.
So there was a check left to us for him, and we went to deposit it in an account so he wouldn't blow it all.
Right.
The thing of it is, he's not a minor anymore. He was when she died. But by the time the estate was settled, he was only 2 weeks from being 21.
Okay.
So my question was, they said we couldn't cash a check. It had to be put into a trust.
And a trust for him.
For him, correct.
Right.
My question is, since he's an adult now, if the three of us went together, can we cash the check like that, or does it still have to be put into a trust?
Well, in other words, the check was never put into a trust, you're saying?
No, the check was sent to my wife a couple of weeks, like I said, prior to his 21st birthday.
So it's
And
payable to your wife in trust.
And I. So.
Your wife and you in trust for what was then a minor but is now an adult.
Correct.
Well, I will tell you this. I am not a trust and estates attorney.
Okay.
But from my general knowledge, I would say there should be no problem with the three of you going into a bank and cashing that check now. You and your wife are the two who it's made out to. You're the trustees.
That's correct.
And then the beneficiary is also going to be there and
Right.
is now an adult. So I would not see any reason why a bank would not cash a check, at least if you're opening an account there.
No,
Otherwise, I could see,
The teller may have you go through a banker.
Oh,
so,
sure.
But they probably could straighten it
Right.
out.
I would think
Okay.
that would. I think that would go relatively smooth.
Because like I said, we were just going to open an account so he didn't blow the money, right? Give it to him as he needed it.
Right.
He's still very wasteful when it comes to money. So, but if we could do that rather than going to a trust lawyer and all that.
Oh, absolutely. Oh, no,
deal.
gosh. For this, you don't want to go to a trust lawyer. No. I think you could just go to the bank.
Okay, that's what we'll do then. Thank you very much for your
All
time.
right. You're welcome. Take care. And I think we now have Bob on line 2.
Mm-hmm.
Hi, Bob. How are you?
How are you, Stu?
I'm doing good. How can I help you?
This has to do with, I guess, malpractice. I had an operation on, I had a broken clavicle, a collarbone, and prior to that, I had a separated shoulder, and still separated to this day. When you went in and did the clavicle operation, the bone is like sticking up in my shoulder, and it's like almost ready to rip through the skin. It's so obvious and ugly.
The clavicle?
And yeah,
Okay.
right on the joint it broke. They had to put a piece of steel in with screws and everything. But prior to that, I had a separated shoulder, and I still have a separated shoulder. And I still got pain in that shoulder and the numbness from the operation, and it's never going to be right. And I don't know. Did he have any responsibility to do anything with the separated shoulder while they had me opened up?
No,
or,
actually, no.
No?
If the operation to be performed was on the clavicle, that's the responsibility. If there is an emergency that occurs during surgery, then they take the measures that are needed to take to protect you, and then afterwards, anything that is not life-threatening, they can ask you whether you want done or you can schedule it. But to repair the shoulder would not be something they would necessarily do in repairing the clavicle, although honestly, I don't know why any doctor you went to would not have scheduled the operation simultaneously.
And I'm not happy with the clavicle operation. If you saw this, it's got to be the ugliest clavicle operation. I saw the Green Bay Packers had a broken clavicle, the quarterback.
Right, yes.
And,
Aaron Rodgers.
I looked at his Rodgers, yeah. I looked at all his X-rays and everything, and he played football almost like less than a year later. Well, I had my operation over a year ago. This thing is a mess, and it looks as bad as it feels.
All right. Well, then, what you probably should have you gone to another specialist for a second opinion as to whether or not the clavicle surgery was performed properly? Is the word I'll use for right now.
No, I haven't got an opinion on it yet, but I have to go have that separated shoulder done. So while I'm there, I'll get an opinion of that from that doctor while I'm there. But,
all right.
He said the doctor who did the operation told me, he goes, well, it was like he take the steel out down the road, it'll go down somewhat, but I'm talking about almost an inch. This
right.
thing is sticking up out
well,
of my shoulder.
I think that's when you go to a specialist for a second opinion. If that doctor says that the surgery was performed, the technical legal term is below the standard of care, then you may have a professional negligence or malpractice case against the doctor. If, for whatever reason, it looks ugly, it feels bad, but the surgery was performed within the standard of care, and that's just an unfortunate result, I can't answer that. That's really for doctors, because when it comes to a medical malpractice case, there are special rules, and you can't even file a medical malpractice case until you have two experts, usually specialists, who are willing to sign affidavits that the doctor that you're suing was negligent. That's a prerequisite to filing a malpractice case.
Yeah, I heard it's difficult in Florida.
So the first step is getting somebody to give you an opinion, and then you'll be more informed. And if you do need an attorney, at that point, you have somebody who's told you, maybe that the first doctor was negligent, and then that attorney may take a medical malpractice case and send you to a specialist that they like to get a second opinion, or really a third opinion.
Is there a time frame that
Yes.
expires?
Yes, malpractice. I'm off the top of my head. I believe it's 2 years.
2 years. All right. Thank you, Stuart. I appreciate it.
You're welcome. Take care.
Bye-bye now.
Bye-bye. Well, all right. That's
So,
a nice.
orthopedic surgeon first.
Right.
If he
Absolutely.
says this doesn't look right, then
Yeah, the standard is, did the doctor perform whatever action he performed below the standard of care? And the standard of care changes depending upon what is done. If you're dealing with a general practitioner, there's one standard of care. If you're dealing with a cardiologist, there's another standard of care. Orthopedist. they all have to act within the standard of care of the type of doctor they are with the experience level that they have. And that's why you always want a second opinion if you don't think, a surgery was performed properly and that doctor can't remedy it. So we now have a third call, which is wonderful. I guess nobody likes my singing, so they want to keep me away from it. And we have Hannah. How are you, Hannah?
I'm good. How are you?
I'm doing fine. How can I help you?
Well, my boyfriend was actually injured at work about 4 weeks ago. The doctors think that he tore his ACL.
Ooh, ouch.
Yeah, and I'm really just wondering how quickly they're required to get him care because it's taken them about 4 weeks now to schedule an MRI.
Okay, and now has he contacted an attorney, or is he just working straight with the employer and the insurance company?
Just with the employer and the insurance company.
All right. I will tell you honestly, in my view, that's a mistake.
Okay.
Now, it may start out the employer may have his best interest at heart. The insurance company, may do what they're supposed to do, but I never trust it down the road. And getting care sometimes, as you say, is delayed. An attorney that specializes, in workers' compensation actions, they know all the tricks, and they know how to get appointments a little bit quicker than you might otherwise get one. I agree that a month, to get an MRI, I think that's outrageous.
Yeah, that's where I stood as well. He's just not the kind of person that likes to call people or really get overly involved in anything.
Sometimes that's what you have somebody like you there for. You help
Very
him
true.
with those things, and I'm sure he helps you in the areas that you're weak. So
Yeah.
I would say you should call a workers' compensation attorney. There was one that I had as a guest here a few weeks ago. Obviously, you don't need to call him. You can Google, but his name is Andy Reich, R-E-I-C-H, at Reich and Mancini in Port St. Lucie. I trust him. There are plenty of other good workers' comp attorneys. You can either Google them, or a great site to go to check out any type of attorney is avvo, avvo.com. They sort of rate all attorneys across the country, but in addition to that, you can often see a lot of reviews. And I tell people, I have 50 reviews on that site. And so, I tell prospective clients that call my office, you can always see one or two reviews from somebody. I wouldn't hire a plumber with one or two reviews because I don't know if I can rely upon them. It could be the cousin and, the ex-wife. But when you see attorneys that have 5, 10, 15, whatever reviews, especially if they're not all good necessarily, although you hope so, but if you start seeing similar themes, like the attorney always calls me back, the attorney always tells me what's going on in my case, that's who you want to call. You want to call somebody that other people are saying not only got me a great result, but was available, accessible, didn't leave me hanging. And so I go check avvo.com and, put up workers' compensation and, the city you're in or an adjacent city. And you should find the workers' comp attorneys that are local, and you'll find somewhat good reviews. And I think those are good ones to call and try to pick from.
All right, awesome.
All right, I hope that helps, and I hope he gets better soon.
It does, yeah. Thank you so much.
You're very welcome. Take care.
All right, bye-bye.
That's 3. Should I sing again?
That might work.
Let's see. What can I sing? I did it my way. That's how I handle the trial. I do it my way.
Well,
I often play that right before I go into court for a trial. But, that's only one little bar, so maybe it'll get some calls. If not, I may have to sing more. All right. So the first thing I was going to, my sister's yelling, no
more singing
on Facebook. The first thing I was going to talk about, actually, was lack of professionalism between your attorney and the other attorney. The goal is for your attorneys to treat each other professionally and with respect and not get mired down in the emotional angst that the two clients have. Okay, that's why you hire an attorney.
Okay, so in other words, don't take your work home with you.
And don't so identify with the client that you can't be dispassionate and objective. Now, sometimes there are attorneys, that cross that line. Sometimes they don't quite cross the line to unethical, but they are at the borderline. I had one last night. I got a motion to dismiss filed in a case that I have. And, motion to dismiss.
Now you're trying to dismiss it?
No, the other side's trying to dismiss it.
Mm-hmm.
And that's standard. These days, in response to a complaint, almost every complaint is hit with a motion to dismiss.
Okay, yeah.
And when I first started practicing law, motions to dismiss were for if you really thought there was a defect. Otherwise, you just answer the complaint.
Let me ask you this. Is that like kind of kicking the can down the road?
Well, it's one way of delay.
Okay.
And it's one way of holding off on having to answer a complaint until you get more information. But these days, it's the standard. So there are three things that this guy says in this motion to dismiss, which is supposed to be the complaint. The claim for battery doesn't state a cause of action because. Legal reason, legal argument.
Mm-hmm.
Okay.
Mm-hmm.
He says most of the allegations are nonsensical. I don't see a legal argument there. Nonsensical seems to be more of an attack on me. Then he says, about one of my causes of action, it appears to be a new and novel cause of action created by the imagination of plaintiff's counsel. Ooh. I guess, I'm creating something brand new and I'm just
you might just
imaginative.
but you may be a trailblazer. This might be really big.
Well, then what happens to the trailblazer is you lose in circuit court. You maybe even lose in the Court of Appeals.
Oh.
Then you have to look for the Supreme Court to say, okay, we're going to create new law.
All right.
You don't want to do that.
No?
Clients don't want to pay you
Wouldn't
for that.
that law have your name on it then or something?
It would, but it would be very expensive to get there.
Oh, all right.
And then he says, this is a further example of sloppy and lazy pleading. Those are three pot shots at me. Now, you might be able to, I guess you're listening to me on the radio if you're watching on Facebook Live, or if you check out the video version on WPSL TV on
when
YouTube.
We upload it.
You may see that I'm grinning. I have a smile on my face. And that's because it didn't irritate me. I was going to use a different word. It amused me. Because, first of all, those pot shots are not going to impress a judge. Those pot shots say to a judge, maybe you don't have real argument. Also, those pot shots come very close to me being able to file a bar grievance against the attorney. Now, I'm gonna, and it's important for other reasons, not just me. I'm going to read you a couple things. This is from the Rules of Professional Conduct for Attorneys in Florida, the Guidelines for Professional Conduct. To the judiciary, a lawyer owes candor, diligence, and utmost respect. To the administration of justice, a lawyer unquestionably owes the fundamental duties of personal dignity and professional integrity. Coupled with those duties is a lawyer's duty of courtesy and cooperation with fellow professionals for the efficient administration of our system of justice and the respect for the public it serves. Now, in another section of that guidelines, it says, a lawyer should be courteous and civil in all professional dealings with other persons. Lawyers should act in a civil manner, regardless of the ill feelings that their clients may have towards others. Lawyers can disagree without being disagreeable. Effective and zealous representation does not require antagonistic or acrimonious behavior. Whether orally or in writing, lawyers should avoid vulgar language, disparaging personal remarks, or acrimony towards other counsel, parties, or witnesses. And to sort of sum it up, another section says, counsel should always be civil and courteous in communicating with an adversary, whether in writing or orally. Neither written submissions nor oral presentations should disparage the intelligence, ethics, morals, integrity, or personal behavior of one's adversary. I think that comes perilously close to violating the rules of professional conduct. Now, do I run around filing bar grievances against other attorneys? No, I filed one. And I think I've had 2 filed against me. Okay? None of which went anywhere. It's not supposed to be something you just do all the time. Oh, my paralegal saying hi, I guess she's impatient. Hi, Cheryl. Yes, my paralegal's name is Cheryl. Cheryl was out last week on a cruise. Call Cheryl. Tell her about your prospective case. Ask her about her cruise. So now I've mentioned Cheryl's name, I think about 6 times. Now, go back to work, Cheryl, and listen to the show. Okay. The point I'm making is, all too often these days, and in the early part of my career, I admit I was one of the guilty ones. All too often these days, the initial contact between attorneys is nasty. You don't know each other. You have no idea.
I just thought all attorneys played golf on the weekend.
No.
No?
Not like doctors.
Oh, doctor. That's right. That's
No,
doctor.
no.
Doctors.
You know, attorneys may play other games, but they're more deadly. I don't know, maybe Russian roulette. I don't know. Where you pointed at the other side.
Yeah. Okay. Yeah. Okay.
But I think I mentioned at some other show. These days, I basically have 2 types of relationships with other attorneys. One, for the most part, is either we begrudgingly get along, or we get along famously, even when we disagree. And you want to know something? That's when cases settle. When the attorneys can talk to each other, work through things, and go back to their clients and make good recommendations, that's when cases get resolved. When you have the other type of relationship where I just want to destroy this person, he's a nasty SOB, things don't get resolved, and what price is paid? The price is paid by the client. Mm-hmm. If the client's paying you an
both clients.
That's right. Absolutely. Yeah. Absolutely. If the clients are paying an hourly fee, it's paid in the pocketbook. If the clients are on a contingency fee, it may be paid in the end result, or how long it takes, or a whole host of other ways. But, I have a few attorneys that I know, if I see them on the other side of a case, it's not going to go well. It's going to be nasty fighting all along. And hey, look, after 33 years, I'm perfectly capable of nasty fighting. I can throw knives with the best of them.
See, in that first initial case that you work with that attorney,
right.
If you meet that attorney again,
absolutely,
forget about it the next time too.
This is why, and I admit, I did not understand this early in my career. This is why you try to cultivate professional relationships with the people you deal with. You are likely going to see them again. One case, one client, is not worth sacrificing every other client in case it's going to come, because that attorney now despises you. Mm-hmm. I don't know whether it's a matter of maturity. There are plenty of younger attorneys that understand that from the get-go, I'll admit that. And some older attorneys who don't understand it at all.
They never get it?
They never get it. I can think of one right now. I will admit, in the early years of my career in New Jersey, I definitely did not get it. I started every case as nasty as I could be, figuring I'll wear them down. Okay, well, that's how I was trained. It's not the best way to go, I admit it. There was one time when I was with a 200-attorney firm in South Jersey where I went to a 2-day seminar, and it was called How to Deal with an SOB Litigator. They actually have classes on this. How do you deal with somebody who's acting like that? So, because it's such a large firm, in order for them to be willing to pay for it, I had to come back and at a monthly department meeting, give a report on the seminar on what I learned. Well, I didn't get very far into Well, I went to this seminar dealing with the SOB litigator
Yeah.
when the chairman of the litigation department, who was the former New Jersey Attorney General, interrupts me and says, "You went where? What? Did you go as an exhibit?" Yeah, I had a reputation. Okay.
All right.
I had a
So you
reputation.
sat there and you said, "Oh, this is me."
I did, well, it didn't.
Oh,
It
no.
didn't. It didn't quite click then. I was proud of that comment. I went as an exhibit. That gave me a source of immense pride. It was misplaced pride, but down the road, you sort of figure out when you make some mistakes. If you're a smart guy or woman, you look at what you did, and hopefully you modify it.
You learn from it.
You learn from it. I had one case where there was an expert on the other side, and the expert had lied on his resume. For experts, it's called a curriculum vitae, but for us laymen, it's called a resume. He had lied on his resume about a degree he had. So I had perfect way to destroy the guy, humiliate him, make his testimony worthless, and I was just waiting. And so the other side put on their expert, and then it was time for cross-examination. And I went at him with that, and I humiliated the guy. And I turned around with a flare like you see on TV. "No further questions. I'm done with this guy." And stormed back to counsel table. Very effective. Okay, I won the case. But the second I turned my back on that witness, I knew something. I had made a mistake. Not because I had confronted him on lying about his degree, but because the testimony he had given didn't hurt us at all.
Oh, yeah.
Since it
So
didn't hurt us,
you hurt him.
there was no reason to destroy
unnecessarily.
him.
Okay.
And it turns out when I had passed the Florida bar and I was going to move down to Florida, I was still living in Jersey, so one of the options I had to be sworn into the Florida bar was to be sworn in by a New Jersey judge. Fills out the paperwork and gets sent in a member of the Florida bar. So this particular judge I had that case with, I was in front of constantly. And we had a very good relationship, and I won virtually all of my arguments in front of him, which is why I like him so much. He's retired now. And so I made arrangements to meet him in chambers, and they understood I wanted him to swear me into the Florida bar. So this was about a week before I was going to move to Florida. And I go in and, you sit down, you chit-chat a little bit. Why are you moving to Florida? And, we're sorry to see you go. And, I told him he was my favorite judge, not just because I won a lot, but because I really thought he tried to follow the law and he cared about getting it right. And then I said to him, I think I need to apologize for something. He said, "Well, what's that?" I said, "Do you remember that case I had in front of you? It was a racketeering case where it was like $300 million case, and we won without ever having to put on our case on a motion for dismissal. And there was that expert that, had lied about his resume." "Oh, yes, I remember that." I said, "Well, when I turned around to go back to counsel table, after I basically got him to admit that he had lied, I realized I had screwed up. That I didn't need to embarrass this person who really wasn't a party, didn't have a stake in the case. He was just a hired gun. I didn't need to humiliate him because he hadn't hurt us with his testimony." And the judge looked at me and he said, "I am so glad you realize that, because I realized it the instant you did it, that there was no need for you to do that, and I was not pleased."
Well, you weren't either. If you caught it that quickly, then you knew that was the wrong thing to do.
There was nothing I could do about it then, but I did realize once I did it that I'd made a mistake. And I guess, for whatever it was worth, he was glad that I brought it up and that I realized it because, he realized it too. And all that goes to really show is that, judges know what's going on. You treat your fellow counsel disrespectfully, they know. especially if you do it in the courtroom.
Mm-hmm.
They see it. It reduces your credibility. We have about 20 minutes left. I may have to start singing, folks. So give us a call, 340-1590. 340-1590. Or I'm going to sing. I don't know why that's in my head today. Maybe because I'm going on a cruise in 2 weeks. I'm going to be doing.
You feel like singing?
I'm going to be doing karaoke.
Oh.
So, it's in my mind. But that is, you don't. If you find that you have an attorney who is either being a jerk, you may love it because he's being a jerk for you, but you may be paying a price too.
But do you know that he's being a jerk when he contacts the other counsel? I mean...
Well, if it's in writing and you're copied on materials, you can tell he's being a jerk.
All right.
You may not know, from a telephone conversation he had with the other attorney, you may know when he calls you to describe it and tell you what happened and is so pleased with him or herself.
But you might be feeling like you're getting your money's worth.
You might be. And sometimes it's a good idea, but sometimes it's very counterproductive.
WPSL.
Most of the time it's counterproductive. And if you find that the other side has an attorney that's being a jerk, you really should be discussing it with your attorney as to what can be done about it. Because inevitably it's going to delay things, it's going to complicate things, and if you're paying hourly, it's going to cost you more money. If you're on a contingency fee, who knows when you're going to get any money or what other complications are going to arise from the fact that one of the attorneys, maybe on the other side, is just let's just say a horse's rear end, or donkey's rear end. Sorry. I'm getting my metaphors wrong. Do we have a call? We do. The threat of singing. Oh my goodness, 2 of them. On line 1, we have Patrick. Hi, Patrick. How can I help you?
Hi, I'm fine. How are you?
I'm doing great.
Yeah.
What can I do for you?
I have a question about a landlord-tenant situation.
Sure.
I'm the tenant.
Okay.
I've lived where I have for maybe 7-8 years, and my initial contact was with the owner, and I had a lease agreement with the owner. However, 2 or 3 years into the lease, the owner turned it over to a realty company.
Okay.
And now I'm renting from the realty company. I'm paying them.
Okay.
But there's several things that's been broken in the house, and I've reported them each year when they have their lease inspection, and nothing's being fixed over the years. And my rent has gone up 50% during this time.
Really? Okay.
Is there something I can do to make them fix things like the front windows are bolted shut because the locks are broken, and the rear glass sliding door doesn't open?
All right.
Ceiling.
Excuse me. Yes and no. Florida statutes prescribe certain things that landlords must take care of. If it's one of those items, then yes, and a proper statutory notice to the landlord can deal with it. Excuse me. For the most part, though, it's a matter of contract. It's a matter of what's in the lease. The lease often says the landlord's responsible for these things, the tenant's responsible for those things, or the landlord's responsible for these things, the tenant's responsible for everything else. So I can't honestly, and this is what I tell anybody who called my office, I need to see the lease. I can't honestly tell you who's responsible for what, with the exception of items that may be in the statute, which honestly, I don't have memorized except for the fact that they have to provide heat. Don't ask me why they have to provide heat in Florida. I would think it might be air conditioning, but the statute says heat. So, if your heat was broken and they weren't fixing it, you would do a statutory notice, and if they didn't fix it, you would have the option to either fix it and deduct it from your rent or to terminate the lease. A door that's not working or a window. Now, I would think a window that is barred shut would probably violate a local ordinance, in which case, yes, the landlord would have to take care of it, or you'd have, various rights that are set forth under the statute. But as for, general things, the refrigerator breaks, That's usually a matter of contract, and you have to look to the lease document to determine, who's responsible for it. And if the lease is silent, it's the tenant.
Is there somewhere he can Google to find out what things are covered?
Yeah, the landlord-tenant statute in Florida. You can Google landlord-tenant statutes.
Florida.
Florida. You'll get the chapter, and there is if I could, I would do it right now. But there is a section within that one chapter on residential landlord-tenant that talks about the items that a landlord must be responsible for.
Okay.
So that's the first thing I would try to do.
Being able to secure the property, meaning window locks, would be kind of important to everybody.
Locks, I'm not sure of, but if a window will not open, then you have a fire hazard.
Mm-hmm.
Well, if the window's actually bolted shut.
Then I think it's probably a violation of a local ordinance. It's a fire hazard, and yes, I would think that the landlord definitely has responsibility for it. And I think if you called, code enforcement, they might come out and, either write a warning first that you can then give to the landlord or the property manager before they actually cite him, and that might get that thing repaired.
Or windows that don't lock because the lock is broken.
Right. The windows that don't lock, I don't know about, but if a window is bolted shut, I'm certain that's a violation of a local ordinance. I'm certain that's a fire hazard.
Okay. All right.
All right.
So start with code enforcement?
Start with code enforcement, and then Google the statute. You can see the other things that landlords are required to take care of.
All right, I'll do that. Thank you so much.
You're very welcome. Take care. And before we take Mike, let me just say hello to Glenn. I know y'all don't know who Glenn is, but let me just say hello to Glenn. All right, and we have Mike on line too. Hi, Mike. How are you?
I'm fine, thanks. Good morning.
Good morning. How can I help you?
My car was wrongfully repoed.
Okay, I've heard that story.
And it took 70-something days for them to release my car back to me.
Okay.
I hired an attorney, to try to settle loss of use, and I came up with a figure of like $50 a day.
Okay.
My car's worth about $15,000.
Okay.
And he said to me, well, I need a key witness to testify that replacement to rent a similar car would cost $50 a day. Is that a little ridiculous? I'd have to hire a $200 person to come testify that $50 a day is reasonable?
If it was actually going to go to trial.
Yeah. Well, the repo company wanted to settle for $1,500.
Right.
I paid the attorney $2,500.
Right. What was the amount you were seeking? If it was $50 a day, 10 days is $500, 70 days is what, $3,500?
Right.
Okay, so let me ask you a question now, because my attorney says attorneys and counselors. The attorney, I give legal advice. The counselor, I'm supposed to temper that with practical advice. Mm-hmm. You paid $2,500 to an attorney to go after $3,500?
Right.
Why? Let me ask you honestly first. Why do you think that was a good expenditure of your money?
Well, no, I did. Well, I thought I can go after a lot more than that. He's telling me I can't.
What did you think you could go after?
Well, I mean, the embarrassment, the anguish,
No. That's probably nothing you can recover. I mean, loss of use, yes. And see, if you're in a trial, the court doesn't know anything other than facts that are readily ascertainable. Like, the court could take judicial notice of the time the sun rose. Because, there's no dispute about it, and it's very easy to find out for any area. Mm-hmm. The court could take judicial notice of what the weather was on a particular day. Mm-hmm. The court can't say what the value of use is. You would need a witness. Now, that doesn't mean you need to go hire somebody who's going to, charge you $200. I mean, I would hope that attorney would know somebody who could qualify enough as an expert, not necessarily because they're in the rental car business or what have you, but just because they're familiar, with the industry. Maybe they rent a lot of cars. that would be able to
Does it have to be a
testify.
person, or can I just get something from a rental car place that with an invoice?
Yeah,
Okay.
or what would Uber cost? I mean, if you needed to hire an Uber every single day, what would that cost?
It has to be a person unless your attorney can try to get a document that is a business record agreed to without having a live person testify. If the other side objects, then you need a live person. The whole idea is that the trier of fact, whether it's the judge or the jury, has the right to see the person testify, to not only hear what they say, but to observe how they behave in assessing their credibility.
And there's nothing else I can sue for besides the loss of use?
For a wrongful repossession?
Right.
Did they damage your car?
Any other hard damages.
No,
but
no
not
damage.
not the soft types of damages like emotional anguish. Not for that type of an action.
Okay. I gotcha.
All
right.
Did the attorney? I mean, did you discuss initially when you went to that attorney? What you could and could not sue for, and what you were likely to recover.
He said, "I'll make you whole," is what he said to me. So I assume he meant $2,500.
Okay. Yeah, because I mean, I would, very often I will have people in my office, and I'll say to them, I can do this. I don't know if you really want me to, because I don't think it's going to be cost effective. And
Gotcha.
sometimes people want to do it anyway. If they make 1,000, they make 1,000. They don't mind if I make 5,000. And sometimes people say, well, no, I don't feel like throwing this amount of money after that amount of money if I'm only going to recover, this little bit.
Right.
Yeah.
And I respect
break
that.
even.
Yeah, I understand that completely.
Okay. All right. Well, thank you for your time.
You're welcome. Take care. Good luck.
All right. Thank you. Bye.
Welcome. Bye-bye. All right, so we have about 7 minutes left. I guess I could do 2 songs. No, I won't do any more singing. We had 4 calls. That was 4 good calls. I appreciate that. So let's talk a little bit about, we're sort of continuing on with the discussion.
Oh, I need to ask you about this letter here
Go
from
ahead.
your lawyer friend. Does that make you, like, it would make me go, now I have to work a little harder to get you back?
Sometimes, yeah, sometimes I do have that reaction. Not with this one. This one was funny. This one was, that's so stupid. That hurts you more than it hurts me.
Okay.
So I don't feel unlike when I destroyed the expert, I don't feel the need to destroy. Now, there are attorneys that do things to me that bring that part out of me.
Okay.
And it's, I go on a nuclear mission. And I throughout my whole
I
career,
like that, nuclear mission.
shock and awe, rain fire down, to quote a couple of presidents. Well, one sort of president.
Yes,
Okay.
it's like, you called me what?
Yeah. I've sort of had a saying throughout my whole career. You fire a missile at me, I'm going to return with a nuke. I know that's not fancy or eloquent or anything, but it represents my attitude. Except in New Jersey when I was in large law firms, the biggest law firms in the state, we had instant credibility. When I was at smaller law firms in Florida, and now that I'm a solo, whenever you deal with the name law firms, the law firms that have offices in 27 states and 18 offices in different parts of Florida, and they see they're up against a solo, they start salivating. It's gonna be easy. They're gonna bury me in paper. I sort of let them know from the very beginning, don't even try it. You send me 10 interrogatories, I'll send you 100. You send me 100 document requests, I'll send you 500. And you have to do that right from the very beginning. It's like, I've heard teachers, the first day or the first 2 days of class, you've got to be tough and strict, no nonsense, lay down the law, and then you can loosen up. But if you start out loose, they're going to run all over you.
Ground rules. Yeah.
Okay?
Yeah.
So, if I respond to somebody who's trying to take advantage of me because they think, oh, he's only a solo, and how much does he really know, and how good can he really be? The reaction has to be to overwhelm them, to have the 3 or 4 attorneys they've assigned to the case busy and billing their client so that they sort of figure out, all right, let's at least handle this case in the normal way, not try to intimidate him. Because, let's face it, folks, no matter what, nobody's going to intimidate me. I may not be the best lawyer in the country, but nobody is going to intimidate me. I don't care if you got the good old Attorney General up there. I don't care if you got some of these attorneys that are on the talk shows. Some of them are really good. Some of them I admire. Some of them are jokes. But that's just one thing. It's one part of my I don't want to say character, but just the whole essence. When it comes to the law, I'm not going to get intimidated. I may have to work hard, but nobody's going to scare me. So I hope that answers that question. And as, of course, we don't have much remaining time to talk about some of the types of clients who call and the different problems with types of clients, like the client who simply isn't likable. How do you deal with that if you have to go to a trial? Or the client who's a basket case from the initial consultation. How are you going to get them through the discovery process on a trial? The client who has no documents, but otherwise sounds like a great case. How do you deal with it? Maybe we'll talk about that more next week. For now, I will tell you, tomorrow is a very big day. My good old speech and debate team, Lincoln Park Academy. We are going to the Florida Forensic League State Championships tomorrow. And Davey, we've got to get up very, very early to get down there by 7-ish to register.
Yeah, well, you know what?
Yeah.
You'll be beating the traffic.
Well, that's true. And then we go back Sunday. If one of our students, what they call in the terminology, breaks into the quarterfinals, then the whole team will go back to watch and see how far that person may get, or multiple people may get. Hopefully we have somebody who breaks. I see a couple of our kids that seem to be peaking now in the last tournament of the season. Peaking for the state championships.
Awesome.
Coach always wants you to peak for the championships. So I'm hopeful, but we'll see. Until then, next week, it's I'll tell you the results, and it's Ask a Lawyer. And you call Cheryl at 781-8003. Until next week, have a great weekend. Bye-bye.
This is WPSL Port St. Lucie, the talk of the Treasure Coast.